Okay, and this is Walter Davis of San Diego County Times and the Citizens Internet Television Network. So would you state your name and why we're conducting the interview?
My name is Karan, K-A-R-A-N. I'm an attorney and I represent Steven Martinez, who's an inmate in prison. He's a quadriplegic, and the current issue for him right now has to do with his eligibility for a recall of the sentence.
And tell me about that. Tell me about the recall of sentence.
Well, the legislature recognizes that there are circumstances in which incarceration no longer serves its purpose. Recently, the law has been expanded to include inmates who are permanently medically incapacitated, that require 24-hour-a-day care, and that pose no threat to public safety. My client, this law was passed using him as an example. So he meets the criteria. He's a quadriplegic. He's been a quadriplegic. He was injured in prison, became a quadriplegic in prison. He's a crime victim. He's been paralyzed for about 8 years. And based on the criteria of the statute, he is eligible for a recall. The process requires that the institution verifies that he meets the criteria, that the Department of Corrections, the director, makes a recommendation about whether to grant, actually the department makes a recommendation to refer him to a recall. They don't actually make the decision about the recall of sentence. And then the Board of Parole Hearings makes its own recommendation to the court as to whether or not the court should consider. So the Department of Corrections and the Board of Parole Hearings doesn't have discretion to make a decision about releasing him. All they make a decision about is whether he meets the criteria and whether or not they will make the recommendation for the court to consider whether or not his sentence should be recalled. So even though the governor signed this bill into law starting at the beginning of this year, we have made our petition through the process. The Department of Corrections, the director of the Department of Corrections has issued a recommendation that the recommendation be denied on such grounds as it's not in the interest of justice. Well, that's not for the director to decide. The interest of justice is not a standard in the statute. The only thing that the director can determine is whether or not he's permanently medically incapacitated and whether or not he would pose a threat to public safety. The fact that he's a quadriplegic answers both questions. He cannot take care of himself. He needs 24-hour-a-day care, and nobody can possibly believe that a quadriplegic could pose a threat to public safety. So for the director of the Department of Corrections to raise this issue of interest of justice is way beyond the scope of the statute. Interest of justice issues are decided in courts or by juries. So the director is really abusing their discretion in this case. So now the Board of Parole Hearings has to make an independent decision. They're going to be highly influenced by what the director of the Department of Corrections decides. So we need to make them understand that they have an obligation to follow the law as it's written, to make the determination independently, and make the referral to the court. That's their job. It begins and ends there. It's for the court to decide whether or not the sentence will actually be recalled.
Now, what do you say to the people that just say, this guy committed a heinous crime, he should be locked away for life? Why should he get justice now? What do you say to that group?
Well, he's gotten justice. Everybody in this case has gotten justice. Whatever victims there are in the case have received justice. And it's important to remember that he is a crime victim himself. He's entitled to justice. Our justice system is designed to provide for lawful penalties for criminal acts. penalties that are authorized by law are allowed to be executed against an inmate. It's not, the law does not authorize somebody to be paralyzed as a sentence for a crime. But whatever, incarceration provides a remedy in terms of protecting the public from threats. You put somebody away so they can't recommit, threaten the public safety. And this individual cannot do that anymore. There's essentially what society is being asked to do is pay a premium for security that they're not receiving. We're spending hundreds of thousands of dollars needlessly to incarcerate this individual when we could be spending the money to hire more teachers, to hire police officers, put the money into law enforcement efforts that actually produce a positive result instead of simply incarcerating somebody that is no longer a threat. My client is fortunate enough to come from a very stable and loving family. They are prepared to take care of him. He'll return to his parents' home. He has a network of medical healthcare providers prepared to help support his care. So there's really no justification for continuing to incarcerate this gentleman.
So California taxpayers are paying the bill for people, lots of people like him, in other words. Are there other cases that you can cite in comparison to his?
My understanding, there may be as many as 13 quadriplegics in the system, all requiring 24-hour-a-day care. One of the things that makes my client's case unique, I would imagine, I don't know these other cases, but he does have diabetes, requires insulin. That complicates all the other complications that quadriplegics face, especially considering that with the lack of activity and exercise, blood circulation is severely decreased, and that leads to a lot of other complications.
Wow, that sounds really, really bizarre. Have there been others that have applied to be released that you know of? And what has happened in their cases?
Well, that's one of the reasons that the legislature is looking at this case now, because they passed this law for a reason, and it's the legislative branch. It's their obligation to pass laws that benefit the public, and it's the job of the executive branch to execute those laws. So far this year, there has been one other petition brought before the board in regard to medical incapacitation, and the board has denied that recommendation. I don't know the facts of that. Perhaps this individual was determined not to actually be medically incapacitated. I don't know. But the fact that they're denying these, and the fact that the director has already suggested that this case, my client's case, is on its way to being denied, suggests that the executive branch is not prepared to carry out the mandate presented by the legislature. We have a law that says people who meet these criteria need to be recommended for recall. It's the judge's discretion to make these determinations, not the executive branch.